tell you, my friends, one of the biggest moments for me was when the lead investigator was testifying about all of the evidence that they were taking from the home and inventorying everything. And Natalie Cochran made a point to point out to him a particular bottle of, you guessed it, insulin, and say to him that this insulin doesn't belong to them. It belongs to a neighbor's daughter, and they keep it at the house for the little girl in case she needs it. What do you think about that? Let me bring in our legal eagles. Now I got two high-profile criminal defense attorneys on the program, Michael J. Brown and John Phillips. Good morning to you both. Okay, let's talk about Natalie Cochran here. Is the state proving its case against her? You know, we know they've got the burden. She may seem suspicious, but I want to get your thoughts. Michael, would you start us off, please?
Good morning, Julie. Very circumstantial case, but obviously the defense thinks, hey, they may have done a decent job, and that's why they're going to put on their client as well as the children. Some good things and bad things. You know, when you put your client on the stand, obviously they're subject to cross-examination. For the most part, they're not professional witnesses like police officers, detectives, and crime lab people are for the prosecution. And it also the jury sometimes feels as though they have to weigh the both sides equally, and obviously that's not what the jury instruction is, and the burden always remains with the prosecution. But having said that, once you put a case on, there's always that danger that the jury is going to think, hey, who do we believe more? And that's always a concern. Right, Michael. Thank you for that. John Phillips, to you next, please. Your thoughts on this one?
Now, I don't know the order of things this morning, but I would make sure the kids go first and see if it's even necessary that she testify. She's got a big burden today because, you know, if I'm the prosecutor in this case, because she was a pharmacist, because she counseled people on insulin, I'm almost making her an expert today. I'm going to spend a lot of time going through, you know, her and almost eliciting some expert testimony, and then, you know, going into detail about the Ponzi scheme and, you know, trying to make her look like a fraud or a liar in front of that jury today. You know, those are the two big points that she's going to face by waiving her Fifth Amendment privilege.
Right. I appreciate it, John. I want to play you both a clip from Dr. Paul Uribe. So he's a fairly well-known forensic pathologist, had some involvement in the George Floyd case. So if our viewers at home recognize that name, it may be perhaps from that case. And he testified giving a second opinion on the autopsy of Michael Cochran. Let's listen to what he found.
Specifically, what is his manner of death? Manner of death would be homicide, because there's no evidence that he administered insulin himself. People don't accidentally administer insulin to themselves or given.
We object at this time.
The objection there, okay. Michael J. Brown, what might you have said if you, back when you were a prosecutor, you get the defense objecting to your pathologist's opinion?
The first thing I would have said is, what are the grounds for the objection?
Right.
Listen, we can get experts. Any side can get an expert to say anything. I mean, that's clear. You can pay an expert. They can come in. They can testify and benefit your case. It's really about cross-examining that expert and having the ability from the defense standpoint to neutralize that expert. And I'm hopeful, and although I don't know, that the defense is also going to put their own expert on to counter what the prosecution said. Because if you can neutralize the expert, that's a big deal. And then it relies on, as John said, it's going to rely on Natalie's ability to convince that jury that she simply did not commit this crime.
Yeah, great points. I want to play another clip for you both. This is where Trooper Timothy Bledsoe, who's with the West Virginia State Police, talked about how it was Natalie Cochran who introduced the idea that Michael, her husband, was using insulin.
She indicated that, again, they had gone separate ways that morning and had returned home, and that upon returning home, Mr. Cochran had been sleeping on the couch for approximately 45 minutes to an hour, and that when he awoke shortly after that, he went into the kitchen and had collapsed. And also she introduced that in that interview that Michael Cochran was allegedly using insulin as part of a bodybuilding regimen.
Okay, so the idea that he's using insulin is coming from her. She's denying to own that bottle of insulin that they found in the house and belongs to a neighbor's kid. John Phillips, what do you think when you hear these bits of information about what Natalie Cochran is sharing to investigators after her husband's deceased?
Well, there was also some inconsistent statements about the insulin and where it came from, and some text messages, I think, about administration of insulin and acquisition of insulin. But her whole defense is essentially, my husband was insecure. He was doing all these things because of low testosterone, or to become bulked up. And he just mixed it, and he probably tried to cut it with insulin, and that's what led to his death. But the evidence doesn't really support that. And anytime you're given inconsistent statements, particularly when you've been convicted as a liar, you got problems.
This is true. I'm so glad you mentioned that, my friend. So, speaking of her being convicted as a liar, this is one of those unique circumstances. You both know this, John and Michael. I want our viewers to know this ahead of time as we get ready to watch her on the stand. You can't always bring in someone's criminal history. There are restrictions. It's all, dependent on case by case, but generally it's not coming in, except for crimen falsi is the Latin term. So you have a field day when you're a prosecutor with all of the bad things. Michael J. Brown, so thinking about this lady getting up there, testifying today, I mean, I can't imagine how bad this is going to be when the prosecutor digs in and talks about all her deception and the fraud that she's committed. What do you think this is going to look like?
Well, Julie, that's what we hope for the prosecution. Prosecutors, unfortunately, as we all know, we were all there, don't have the ability to cross-examine as often as defense attorneys do. So now you have an individual who has this conviction, a Ponzi scheme, and the hope is for the prosecution that they don't just ask 5 or 10 questions about that, but they get into the real nitty-gritty details and talk about specific acts that she did to deceive and lie and cover up, because that's in essence what you want to show the jury she did in this case. So if they do it effectively and get into the details and really draw it out, I think it could be very, very effective.
Yes, I'm with you. I can't wait to see this. This is going to be one for the books. We'll leave it there for now, but I'm so glad you both are on the show today. Michael J. Brown, John Phillips, stand by, please. We're going to hit a break. When we come back here.